Hello and warm welcome to Professor Randall Abate, sir. And we welcome you on the Faculty of Law, GLS University's virtual platform. And we are very grateful to you to have you on our platform. Before we start with the further sessions formally, let us just remember the God Almighty.
कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरु.
Thank you. And as we have gathered for the webinar on the climate change and its mitigation processes, we embodied the spirit of Vasudhaiva Kutumbakam, which simply means that world is a one family. We are honored to have Dean Abate, sir, and sir would be sharing his expertise on the topic with us, and let us just welcome him with open heart, minds, and ready to learn and grow together. Randall Abate, sir, Assistant Dean for Environmental Law Studies at the George Washington University Law School. Prior to joining the GW Law in July 2022, he held a full-time law teaching and law school leadership position for the 3 decades at 6 US law schools. With primary focus on the climate change, law, and justice, the Dean Abate has lectured and taught a course in more than 25 countries on 6 continents and has published 6 books and more than 40 law protecting, journal articles and book chapters on his credit. He is the author of Climate Change and the Voiceless, Protecting the Future Generation, Wildlife, and Natural Resources, a Cambridge University Press 2019, editor of Climate Justice, Case Studies in Global and Regional Governance Challenges, ELI Press 2016, and a Climate Change Impact on Ocean and Coastal Law, US and International Perspective of the Oxford Press of 2015. He is also a co-editor of Climate Change and Indigenous People, The Search for the Legal Remedies, an Edward Elgar 2013 publication. He co-authored 2 law journals articles on climate migration governance in 2024 and has lectured around the country and the world on the climate migration issues for the past 3 decades. Early in his career, Dean Abate handled environmental law matters at 2 law firms in the Manhattan. He holds a BA from the University of Rochester and JD and MSL in the environmental law and policy from the Vermont Law School. We are very thankful to you, Professor Dean Abate, sir, for joining us today. And now the floor is all yours.
Thank you very much, Dr. Matharani, for this invitation. It's a pleasure to be here with you. And I have a long-standing relationship with law schools in India, so it's a privilege to add GLS law.
It is an honor for us also to have you on a virtual platform of GLS.
Thank you so much. And it's an issue that's near and dear to my heart, climate migration, and it's a way to bring our 2 countries together on this topic for today's lecture as regional destination hubs for this challenge of climate migration. So I'm sharing. Can you see my slides now? There we go.
Yes.
Excellent. Thank you. So climate migration governance is a global challenge, but today's discussion will focus on how, even though we have a global challenge, in some respects, regional solutions may be our best hope to address this global challenge, and 2 countries that may emerge as leaders in addressing this global challenge at a regional and domestic level are the US and India. So I want to start with giving you a summary of what I'd like to cover here, certainly starting with the idea of why focus on the US and India, why am I portraying these two countries as regional destination hubs for climate migration, and also after establishing their relevance for being receiving nations for climate migration, we also have to acknowledge that these are imperfect regional destinations. Each country faces challenges on its own with respect to internal climate displacement. And there are additional challenges that go beyond just these two countries when we think about how the law should address climate migration. And so we'll discuss some of those in terms of some of the terminology that's being used and some of the realities of how to isolate and determine what is driving climate migration. Is it exclusively related to climate factors, or is it a collection of factors, and climate related factors are primary among them? So we'll also take a look at the existing legal frameworks in both countries, and both have limitations. They certainly have different strengths as well. And there's in each country some promising recent developments that show at least some progress and hope toward enhancing these legal frameworks to do a better job in addressing climate migration governance. And we'll take a look at the end with some other examples outside the US and India, both domestically and under international human rights law, and conclude with some lessons that each country can learn from the other. So first of all, why focus on these two countries? Well, the challenge of global climate migration is enormous, and it's not getting the attention it needs as quickly as necessary. And if we look at how slowly the international climate change diplomacy efforts have moved in the past 3 decades, that should be a warning sign for us that we simply can't look to international law exclusively to be able to fashion effective responses to climate migration around the world. We need effective domestic laws and in countries that are likely to be regional destinations for this movement related to climate change. We're certainly seeing lots of internal displacement throughout the global north and global south. The notion of internal displacement means people are moving within their own countries, and we aren't seeing fully developed frameworks to address that challenge on a country by country basis. So if we're going to effectively address regional receiving of climate migration on transboundary basis from one country into these larger receiving countries, those receiving countries need to have particularly strong laws related to climate migration to not only help their home country, but also to be able to accommodate those who come from outside the country. And it's important to remember that even though some of the literature and discussion about this phenomenon still uses the term climate refugees, it's really a misnomer in this context. We have the 1951 Refugee Act under international human rights law, but this human rights law and how it defines what a refugee is, it does not apply to what we're observing with respect to climate displacement. So the Refugee Convention talks about individuals or communities that feel persecuted, and therefore, and that persecution might be on the basis of religion, race, politics, and ultimately choice to leave their home because they don't feel welcome. And they then make another choice not to return to what they called home because they don't feel welcome there. So you've got choice in both directions, a choice to leave and a choice not to return. With climate-related displacement, we have a situation where populations are being forced out of where they call home, either because some climate-related disasters cause that forced movement, or there is just more of a slow onset progression that makes them need to move away from where they called home because it's unsafe or unsustainable to stay there. And then they are not making a choice not to return to where they called home. It's simply not habitable or safe to return home. So that Refugee Act is not relevant for a governance framework for what we're observing with climate-related displacement. So another reality that we're looking at in terms of focusing at the regional level is that the US and India are advanced economies and the largest land masses in their respective regions. And so that makes them an obvious choice to be a point of refuge, if you will, for climate related displacement for countries in those respective regions. So ensuring that those countries have the domestic law in place to manage this crisis, both internally and with respect to those that migrate into their countries, is going to do quite a bit in addressing this larger global challenge of climate migration. So that's certainly an imperfect solution to the issue, though, because we've got two significant regional destination hubs that are imperfect in many ways as a place of refuge for displaced peoples outside their borders. So it's important to realize just the tremendous scope of this issue on a global basis, that the UN High Commissioner on Refugees predicted that there'll be 1.2 billion people displaced by 2050 as a function of climate-related stressors. Now, that is significantly larger than the rest of displaced peoples for all other reasons besides climate around the world. And that number has gone up in a very short period of time. Just 2 years prior to this figure, I think it was in 23. So 2 years prior, in 2021, the World Bank projected 200 billion people displaced by climate-related factors. So just in the period of a few years, the projected number increased fivefold, and it's still just a very general estimate that could easily be much more than this already significant figure. Very, very hard to project those numbers. The internal displacement numbers are also quite daunting. So a lot of that movement is happening within countries around the world. 60 million already internally displaced in 2021, and here we are already in 2025, and that number is certainly higher. If we look individually at India and US and their challenges, of those 60 million that were displaced in 2021, 5 million were displaced in India that year, internally displaced. And another vulnerability for India is a significant projection about how many 50 to 120 million people that are likely to migrate from Bangladesh to India. And Bangladesh is one of certainly the most vulnerable places on Earth to sea level rise, coastal erosion. And then in the US, we've got a very large coast on both sides of the country, and we're looking at significant coastal resident migration that simply will not be able to stay living near the coast where they have chosen to live due to sea level rise and coastal erosion and severe storms. 13 million projected by 2100 to be relocating inland. So we have some questions about how the law ought to approach this problem, and we need to have right kind of understanding and terminology to be able to have clear legal responses. So the first question relates to the governing area of law that should be in charge, so to speak, of this challenge. The challenge of climate migration, I think, is quintessentially at the crossroads of two major fields of law: international human rights law and international climate change law. And both on their own are imperfect solutions. International climate change law addresses so many things other than migration, and so many initiatives have been discussed for the past 3 decades about what international climate law should be addressing. Climate migration has barely been in the discussion because climate change regulation involves both mitigation of greenhouse gas emissions and adaptation measures, how the law can help us adjust to what the impacts of climate change have been causing and will continue to cause. And climate migration is just one of those dimensions of adaptation. So it's not getting the attention it deserves under international climate change law. And I think there's been more promising progress on the side of international human rights law, although that's also kind of an imperfect fit because international human rights law is so vast. It covers so much more than climate migration. So there is a reluctant but progressing embrace, if you will, that international human rights law has been starting to appear more in the legal governance analysis and scholarship on how to address the climate migration challenge. So that's really the first step, and why we've in part not seen as much progress as we should, because if there's not one area of law that really owns an issue, then it becomes more of a collaborative challenge, and that's just by definition not going to move as quickly. So then we have sort of a scientific challenge, if you will, science and technology challenge to determine what is it that is ultimately going to trigger the law's response to say that there is climate-related displacement, and how do we separate that out? How do we identify that we've got climate migration as opposed to other forms of migration? And there's a lot of reasons, cultural, economic, political factors that contribute to why people move from one place to another. So it's a challenge for the law to determine what sort of portion of that movement is attributable to climate change, such that climate migration law would be triggered to respond to that movement and afford some protections. And then there is the reality of sometimes this displacement is temporary. In the famous example in the U.S. from 10 years ago, Hurricane Katrina, there were many residents from the Ninth Ward of New Orleans that were displaced by that storm, and many of them were temporarily displaced. They had to live in a football stadium, the Houston Astrodome, many miles away from New Orleans, and they were temporarily housed there while New Orleans was being built. And this was a period of months and in some cases years of temporary displacement, but many of them were ultimately able to return to New Orleans, and many did not. So the question arises, would the law be triggered to protect those that have been temporarily displaced, or is it only applicable to permanent displacement? Certainly my argument would be that it should apply to both temporary and permanent displacement. But all along, you have to be thinking about the cost involved in all of this, and how we are just fundamentally unprepared for the degree to which this problem will very quickly bankrupt countries that are not financially secure. And just to give you an example, there was a scenario in Alaska, in the U.S. There are many Native Alaskan communities, indigenous communities, that are being threatened with displacement because they are coastal communities that are very dependent on fishing for their sustenance and their cultural and spiritual lives. And there was one community that needed to move 10 miles inland based on a vulnerability assessment that was conducted by a U.S. federal agency. And the agency projected that that community only had about 20 years to live where they lived. They needed to relocate, and not just relocate themselves, the 400 Native Alaskans, but they needed to relocate all their infrastructure of their community 10 miles away. And the projected cost of that, just moving the 400 Native Alaskans in that community and their infrastructure 10 miles away, was projected at $400 million. And that was 20 years ago. And so just think of that figure, $1 million per person, if you're talking about relocating communities and their infrastructure from a place of danger to a place of safety. And just multiply that out by the populations we're looking at in these countries. So that is really quite daunting. Just the financial challenge alone is really a major obstacle. So the other challenge is this idea of what's in a name. How do we identify what this phenomenon is? And so we've already talked about how refugee is not quite the right term because of the way international human rights law defines that term. But another dimension is that we want to be respectful of toward those that are experiencing these displacement challenges. And refugee has a negative connotation, and we certainly don't want insult to injury, so to speak. We don't want to use terms that may attach a stigma to those that are just victimized by climate-related displacement factors. So then there's the term climate migrant, and that does avoid the stigma concern, but it also is misleading in some ways, like climate refugee, because migrant suggests volition, that you're choosing to move. And as we discussed, much of this is forcible displacement. That these communities and individuals don't have a choice. They have to get out of harm's way where they live because it's no longer safe. So prior to this era of climate migration, we did have a term that existed that was more generic and more broad, known as environmental refugees, and that would include factors that aren't directly related to climate, and this might be earthquakes, for instance, other factors that are not related to climate but are environmental. So there's a wide range of choices to be thinking about as what we do with our terminology. And then we have this issue of, okay, maybe we can change the terminology of migration, since it does imply volition, and use the term mobilities. And this is becoming more used in the literature now, that mobilities is this idea of movement, and it suggests that it's not movement that you chose to make. And then we have the other issue of, previously the idea or the terminology was climate-induced displacement, the idea that climate change was the reason you moved. And now the recognition is that it's very rare for climate change related factors to be the only reason why individuals or communities are moving. And so climate related displacement is now the preferred term to characterize this reality. And that term is in the U.S. climate migration bill that was introduced about 4 years ago. So the existing legal framework in India, strengths and weaknesses, just like the U.S. The biggest gap for India is that unlike the US, it doesn't have this comprehensive statutory and administrative system to address migration. So the US has a robust system of immigration and asylum law, statutory law, to manage migration generally, and this could be adapted to address the challenge of climate migration. India does have the Citizenship Amendment Act, but that has been criticized as being applied in a discriminatory manner in the past. So it's something of a foothold to address the problem, but not nearly as well established as the U.S. immigration and asylum law system. So where we see very positive developments in India is the court system. India is world renowned. The activist court system that it has which enables judges to, for lack of a better term, do the right thing, to create law, to go outside the boundaries of what a particular statute or constitutional provision might say, and promote justice on a particular issue. And so there are very ambitious and progressive decisions that have come out of India's court system over the past few decades on environmental issues and the intersection of environmental and human rights issues, much more progressive than the US courts that are much more constrained by our Constitution and the separation of powers between our three branches of government. That's been a significant limitation, and courts are widely criticized in the US if they do issue what we would call activist decisions, as opposed to having a more restrictive role in interpreting what their mandate is. So certainly the issue of climate migration has received virtually no attention in the US, but we are seeing very encouraging signs in India's courts to address this challenge of climate migration through a human rights lens, which is very useful. On the flip side, the US has the reverse of strengths and weaknesses. So there's a lot of potential to use existing immigration, asylum, disaster law in the US, very robust statutory systems we have that are not designed to address the challenge of climate migration because they're quite old and we didn't know about climate migration when these systems were enacted. But they have the potential to be interpreted in a way that is mindful of climate migration and could be potentially useful tools to manage that crisis. But we have some very embarrassing gaps. The example I just shared with you about the failure to protect indigenous communities like the Kivalina case, the Native Alaskan community, that's true of indigenous communities around the country. They are very much in need of relocation assistance generally from coastal, very vulnerable coastal areas. And there has just been no system of federal funding or support for their plight. And so even though we have this capacity of existing law and frankly, plenty of funding, that simply is not being applied to address these challenges. So there's a lot of potential there, and it's not being used really much at all yet in the US. And the oversight, or rather the failure to respond to the indigenous community's plight has gone on for 2 decades now. Since that Kivalina case 20 years ago, they are still trying to find a way out from that place of vulnerability in northern Alaska. And there are other communities around the country that banded together and filed a petition with the Inter-American Commission on Human Rights, seeking to compel the US to provide that relocation funding and technological assistance to ensure that these communities can get to a safer place. And we're just starting to see those kinds of efforts in the courts in the US. So not as many encouraging outcomes yet, as we've seen in India, but certainly that is now a trend that has started to develop quite rapidly in the past 5 years anyway. There's been a lot of strategic litigation on behalf of other communities for non-migration concerns. So there's lots of youth climate litigation that's seeking to compel the government to address climate change more ambitiously. But the idea of migration isn't getting the attention that in the US that it has in India in the courts. So some promising recent developments: a May 24 Supreme Court of India case actually concluding that there's a right against the adverse effects of climate change under the Constitution. Articles 21, right to life; Article 14, right to equality. So this is very encouraging, and we're seeing other types of courts in Latin America use this rights-based thinking to protect affected communities from the impacts of climate change. But in this case, in India, it's been applied to climate migration, which is very encouraging. So it's certainly kind of opening that door, suggesting that courts must be alive to other rights of affected communities, such as the right against displacement and allied rights. So this idea of recognizing a right against displacement is incredibly progressive, because we've been aware of climate migration as a major threat internally and on a transboundary basis for well over a decade, and this notion of a right against displacement is just beginning to emerge. So India is really a global leader with this kind of language coming out of its Supreme Court. So that's a very encouraging sign of progress. In the US, really just more talk than anything. We were on a much better track under the Biden administration on all things related to climate than we are now under the second Trump administration. But even under the Biden administration, it was just a lot of talk and baby steps in the right direction, and it just was not happening fast enough. So a Biden administration report was released discussing climate migration as a problem, and that's essentially all it amounted to, was a big words on a page effort to at least raise awareness of climate migration as a concern, but it did not translate into any legal responses. This climate migration bill, as I mentioned, that was introduced, has certainly not progressed in Congress. So it's better than nothing, but it's not too revolutionary what the U.S. has done to date on climate migration issues. So when we look outside both of these countries, there are other countries that are being quite progressive on the legislative side. So Finland and Sweden enacting laws to protect people fleeing their country due to environmental factors. So it's important that there be independent laws rather than kind of repurposing existing laws or trying to use the courts one case at a time to address climate migration. Legislative efforts, even at the domestic level, because as I said, this is going to be very slow and improbable to get any kind of international treaty addressing climate migration. It's just not going to happen soon enough or effectively enough. So we really need these domestic laws that speak directly to the issue, and we're starting to see some of that in Europe, Finland and Sweden. And then Germany proposed a climate passport for temporary protection when you have people moving across borders in getting away from the threat of climate displacement. You shouldn't face the same barriers you normally would when you travel, because travel is a choice. It's a non-emergency situation, and this climate visa proposal, climate passport, is a notion of recognizing the urgency and the need for that temporary refuge when moving from one country to the next, if that's what it means to get to a place of safety, we should be loosening those strict borders in the context of climate migration. So that's a very encouraging development. We've also seen promising developments under international human rights law. The Human Rights Committee had a very groundbreaking decision in the Teixeira case. So it did not specifically define who could be covered within that notion of a climate displaced person, a climate refugee, but at least acknowledged that there's a potential for protection of those who are displaced on the basis of climate change. So it's very common for courts and other tribunals to proceed in this manner. It's such a big step when there's no existing law about climate displacement, and then the first court that is thinking about it doesn't want to take too big a leap. So this is an encouraging first step. We've seen this a lot with other climate-related litigation. It's a get the foot in the door and then keep pushing to get more meaningful protection in subsequent efforts. So this idea that sea level rise could be the basis to protect people who are fleeing from their place of origin from climate-related factors is a very encouraging first step. So that's under international human rights law, and we want the progress on all fronts. We want the development of domestic law, but we certainly welcome the simultaneous development of international human rights law. And perhaps one of the most encouraging recent developments on that front is the trio of advisory opinions that have come out from major international courts and tribunals. So we had an advisory opinion from the International Tribunal on the Law of the Sea, and that came out in May of 24. And then just this year, a few months ago, we had two major decisions, one from the Inter-American Court of Human Rights, and then one from the International Court of Justice. All three of these cases are about state duties with respect to climate change. And in particular, the Inter-American Court and the ICJ decisions had a lot to say about the intersections between climate change and human rights. And the ICJ decision even made reference to climate migration in the South Pacific context, about that threat of a loss of nationhood in those states when they're so vulnerable to sea level rise. What's their future? Because international law requires that countries have a territory to be able to be recognized under the UN system. And at least on a very technical basis, climate change related sea level rise could inundate many of these nations in the next 50 to 100 years. And would that mean they would cease to be nations under our international system? So there's lots of creative efforts to determine how international human rights law would at least be a guard against that loss of nationhood, that loss of human rights that would go along with the idea of being vulnerable to the loss of culture and identity and sovereignty because of climate-related factors. So certainly we have these sort of reciprocal lessons between India and the US. They need to do what the other does well. So for India, the need for that comprehensive statutory administrative framework to address the challenge of migration is certainly something that is an immediate need. The promise of the recent case developments is fine and it's encouraging, but we know very well that we're not going to address anything related to the threat of climate change, whether it's migration or anything else about adaptation or mitigation. We're not going to get very far one case at a time. We have to have progress on all fronts. The statutory and administrative responses and the judicial responses have to be robust in all countries at all times to really get a handle on how daunting this challenge is. So the US is a bit reluctant to take that human rights-based approach, and it needs to. It's just not seeing the climate migration challenge as something that is front and center in related strategic litigation. So we are seeing some promising results in the US. We're seeing youth climate cases now progress to trial and even prevail on issues related to state constitutional provisions. So there are 7 states in the US that have a constitutional provision with varying language, but the general idea is a constitutional right to a clean and healthy environment. And those constitutional provisions have been successfully asserted to be leverage for youth plaintiffs to say their state governments need to do a better job regulating climate change to protect their future. And those cases have succeeded so far in Montana and Hawaii, two of those 7 U.S. states that have those constitutional rights provisions in their state constitutions. But somehow that's not yet translating into addressing internal migration challenges as a constitutional or a human rights concern. So that needs to move forward in the U.S. and it isn't yet. But we have a lot of capacity to use those existing statutory laws that are a strength, the immigration and asylum law system. And just to give you an example, we have an asylum law protection called temporary protected status. And this is applicable to some countries in Central America when they are facing political instability, war, threats of human rights violations. They are ultimately allowed to come to the U.S. for a temporary duration to get out of harm's way. Basically, you're welcome as a short-term guest in the U.S. to avoid what's happening at home. Because that was so threatening to you and posed this imminent danger to your safety, your well-being. So, that kind of approach can be readily adapted for climate change, but it hasn't. So we recently had a situation where the Bahamas, located very close to the US, had a major hurricane, and there were many residents of the Bahamas that wanted to seek temporary refuge in the US. And that logic behind temporary protected status was not extended to the residents of the Bahamas. They simply were not allowed to come to the US, and that's just heartless and wrong on many levels. And so the anticipation of that need to seek at least temporary refuge in the US is going to be overwhelming in the decades ahead, from the Caribbean, from Central and South America, and likewise in India, the influx from Bangladesh, Pakistan, Sri Lanka, the Maldives. There has to be some forward thinking about, it's not if that's going to happen, it's when, and whether the law will be adequately prepared to do its best so it isn't sheer chaos and potentially a basis for regional or global war when populations are desperate for safety. That can escalate quite quickly into serious political destabilization around the world. So I'm grateful for your attention to all of this, and I'm eager to hear your questions and comments. Thanks so much.
Thank you, Dean Randall Abate, sir, for sharing. It's so insightful a session. I'm sure that students are having questions, and most of them have been answered. What I can read from my system, but there is one question from Kedar Sirana. I hope you can read that also from the screen. He's saying that what is the single most critical legal barrier in the US and India preventing effective protection from the climate migrants? You have shared many of them, but what do you, according to you, is the most critical one in the list?
Yeah, I mean, I think in both instances, it is a function of not having a legal response that is independent to the challenge of climate migration. Both countries have the opportunity to address it in a kind of better than nothing way, but we need much more than better than nothing to address a challenge like climate migration. So it needs to be something that is legislatively enacted in each country, because both countries are aware of these impending threats, and it's the kind of thing that wouldn't be ignored if we were talking about preparing for potential war. We would be very sensitive about enacting legislation to enable better protection through buildup of our military forces and whatever kind of responses would need to be in place to ensure our national security. And yet, climate migration is a national security issue. The U.S. Department of Defense recognized that over 20 years ago. And it's also a major human rights crisis. And I think, however, each country wants to frame it in terms of what gets the political will to get this issue front and center before legislative bodies, that's the biggest barrier in each country. It's a problem that's not being discussed enough. It's a problem that isn't perceived as sufficiently urgent, and that needs to change very quickly in both countries.
One more question is that the person is asking that what specific domestic legislation should the India and US prioritize to officially define and support the climate displaced people? I think you already have shared one which was not successfully passed in the Congress in the US, this thing. And we also have attempted in 2022 for the climate migrants and the rehabilitations of the uh, same, I think, in 2022, but that also somehow was not passed in our parliament. But in case if you want to add further in this regards.
Yeah, I mean, I think there are so many levels of governance on this issue that what we're certainly realizing in the U.S. is that we certainly have no faith in international governance of climate change, in part because the U.S. isn't playing the role it should. And of late, we don't have any faith in even national governance of this issue. So what we're starting to see more of in the U.S. is that, there are so many levels of governance to this problem that trying to do as much as we can at the state and local levels can be very useful, especially when you think about the leverage that some of our states have as economic and political forces. So, for instance, the state of California, if it were a country, would be the fifth largest economy in the world. I mean, that's just one of our 50 states. So when you think about the kinds of responses that a state like California can take on an issue like climate change, is really quite impressive. And they happen to be in the right mindset to be progressive on climate change, which is very fortunate. But we have 49 other states, many of which are not progressive. So it's a matter of finding leverage where you can. So one recent development that's encouraging is this notion of receiving communities. And this is a way where different cities can arrange into a partnership between themselves. And there are certain cities that want an influx of people. It's going to be good for their economies. And then there are, of course, other places that are going to need to go somewhere to get to a place of safety. So there are some cities holding themselves out as these receiving communities. Buffalo, New York is one, Duluth, Minnesota, Cincinnati, Ohio. And of course, there are many places where people are going to have to relocate, like South Florida. And there are at least conversations beginning about making those connections of sister cities, about one being receiving and one being the sending community of people who need a place to stay. So I think that's an encouraging way to go about it. And then we have to be mindful of just how interdisciplinary this issue is. And so there's a lot of discussion across disciplines now. It's not just a legal problem. Lawyers are conferring with urban planners, sociologists. I mean, just that process of resettlement is so traumatic. I mean, the cultural realities, the interpersonal and social adjustments that go on in moving from one place that was home to a brand new place, and how to settle into that new place. So yeah, I mean, there are ways we can make progress from the bottom up, while we're waiting for something more significant at the national levels. We can't sit and wait. We just have to do what we can.
There is one more question. Thank you for answering the previous one. Kritika is asking, how can a destination hub in US and India secure the massive funding needed to build infrastructure for climate migrants? Basically,
Yeah,
she's asking maybe for international fund or something.
yeah. There's an important discussion that needs to be had there, because this is not something that happens uniformly across the globe. There are going to be hotspots of this transboundary displacement, and we want to make sure that there is adequate funding and adequate infrastructure support to accommodate the influx. And so it's, again, a global issue that even if we don't have an international climate migration treaty in place, we certainly can have international cooperation such that if you're not a receiving nation, you certainly, in the global north, have a duty to provide funding to a global fund that would be used to support receiving displaced peoples across boundaries. So, for instance, if you think about the Pacific Island nation scenario, that Australia and New Zealand are the most likely destination countries for a massive number of island nations, and that's certainly unfair for Australia and New Zealand to foot the bill for all of that resettlement that would happen across all of those island nations. So that is a global problem that requires a global, at least funding response to ensure that those communities and countries that want to relocate to Australia and New Zealand can, and also potentially outside the region, and that there has to be that shared responsibility of funding and logistics to accommodate those movements.
Okay, one more question is there. Om is asking about that given the polluters pay principle, how should the major polluting industries in both the US and the India contribute to financially to support this crime, destination hubs? So probably you want to establish those principles of environmental jurisprudence, that whether these private industries should be held liable or can help in providing the fund or support these destination hubs.
Yeah, we're seeing promising developments there. Certainly, they have a moral and legal obligation to pay a significant amount of money. Just a statistic as a starting point, there are approximately 80 multinational fossil fuel corporations that are collectively responsible for about 2/3 of global greenhouse gas emissions, and that's just shocking. When you think about, as a lawyer engaged in strategic litigation, I mean, that's a very encouraging statistic in terms of promoting accountability and liability when there's so few culprits and such a large impact that they're having with an global environmental problem. So in the U.S., there's been some leverage points in strategic litigation against these multinational corporations. there's a series of lawsuits that were filed by states and cities and counties, and they are experiencing very high climate adaptation costs. And they're very resentful of that because they didn't cause the global climate change that is now affecting their states, cities, and counties to engage in the building of seawalls or the wildfire management responses, anything that is a climate change impact happening where they are. They have filed a lawsuits around the country against about 24 of those major multinational corporations, oil and gas companies, and they are seeking contribution to those very significant climate adaptation costs. And the lawsuit has a really compelling theory because when we think about these corporations, they uniformly knew about the harm that climate change would cause decades ago, and they withheld that information from the public. And then once the public had the information, they actively campaigned to cast doubt on what climate science was trying to tell the public about the threat of this problem. So that was harm number two. But perhaps the most grievous of the harms is harm number three, where they actively engaged in disinformation campaigns that they were really trying to change the narrative about climate change, that it was something that was naturally occurring, that it's not something to be concerned about, that we need fossil fuel to be able to function, and we couldn't possibly transition away from it, all the while knowing that that was not true, and they were just trying to hold on to their profit margins as long as they could. And so they were ultimately sued on many grounds, including fraud and conspiracy. And a new term of art emerged in the behavior that they were engaging in, which is known as climate washing. They're trying to convey that their efforts to address climate change were actually helping the problem, when in fact they were very much trying to stay with the status quo. For instance, transitions to blue hydrogen, which is very, very much a baby step away from traditional oil and gas and coal. So there's quite a bit of progress. Those cases are proceeding to trial, and it's certainly creating this publicity campaign of casting a dark cloud on the business practices of those corporations. So that is something that has taken hold outside the U.S. as well. There was a major tribunal, the Carbon Majors petition before the Philippines Human Rights Commission, that also had a very set of conclusions about the proposed liability for what they call the carbon majors, these major corporations and their contribution to climate change. So it's been encouraging progress, and it's just a matter of time before those corporations ultimately will have to pay a lot for the damage they've done over decades.
And I just want to add this thing, and just want to, just asking that I think mandating the, environmental, corporate environmental responsibility, like, as CSR is there, that is corporate social responsibility. In India, we have under companies like that 2% is supposed to be paid back to the society. I think mandating likewise corporates environment responsibility, I think that would be an indirect way for aiding such kind of um, hubs or other environmental concerns. Do you agree to this thing, or?
Can you hear me?
Yeah, I think there was some technical glitch.
Yes, I think it was internet on my side. So I heard you talking about corporate social responsibility, and
And
then I lost
envi-
you.
yeah, so I was just thinking that in case if we make I mean put this as a mandate for all the corporates for environmental social responsibility, I think that would be a great, I mean, way to solve some of the problems of the fundings or aiding the migrants and other environmental concerns.
Well,
So one,
it's certain. Go ahead.
yeah. So one more question, if you allows, probably the last one, if your time permits. Shall we go for
Certainly.
that?
Yes.
So, I mean, the person is asking. So, we have already discussed about the government's role and what government can do, what judiciary's role is there for this thing. Now, the person is asking that why only the government is been made responsible for all these concerns, and why cannot the duty of the individuals to cannot be imposed on individuals for a conservation of environment. Basically, he's asking for and to solve the problems of the climate change.
Yeah, I mean, I think that's always an important consideration that that we're all contributing to this global problem on at different scales. So I always encourage my students because there's this feeling of helplessness that you feel like you as an individual that your choices don't really matter, but of course they do. And of course, raising awareness as an individual to those in your circles matters a lot too. So you know, for everybody, you have daily choices you're making about where you live, about your sources of transportation, about your food choices. All of these have significant implications for climate change, and so it's impossible to be a perfect, neutral carbon footprint in life. But you certainly can reduce the impact that you have by getting the information about um, products you use and how you're engaging with the environment around you on a daily basis. And some of it is not just food choices, but where your food is produced. So, in the US, there's this globalization of groceries that, you go to a grocery store and you're buying food that's out of season in terms of what, the growing seasons where you live, but you're still able to access it and you think it's good and healthy to buy fruit, but there's a major carbon footprint to the fruit that you're getting that's out of season because it's been shipped halfway around the world to land in your supermarket. So it's very important to try to eat locally, to eat organic to the extent that it's affordable. All of these things have diminished impact in terms of climate change. But I think the one that's overlooked the most in the U.S. anyway is food choices, because we have a food system that's so heavily reliant on factory farms that have huge carbon and climate change impacts through methane and carbon dioxide emissions. And people don't think about that as much. I'm a vegan, and that's one of the choices that I made to diminish my carbon footprint. But there's lots of imperfections about transportation too, depending on where you live. I'm fortunate I'm able to take public transportation and walk a lot because I live in the Washington, D.C. area. But when I lived in other states, I was always having to drive, and that's a much bigger carbon footprint. So, but I think it was a message that the corporations sent to everybody, this idea of your individual carbon footprint. It was their effort to deflect their responsibility back onto the consumers. And that's wrong. I mean, they have a much larger contribution to this problem and a larger responsibility. And likewise, governments are the best positioned actors to do something very significant to make progress in ways that individuals never could. So, I think it just has to be all levels of contribution for real progress to be made and not just pointing fingers.
Well, thank you so very much. There are a couple of questions which I think some of them are repeating in its this sense, and some you already have answered, like about India and US legislations on the problems, or what a lesson can both the countries, vice versa, can learn to solve these issues. And I think you already have, I mean, given an example of Sweden and Finland also, that doing actively for these concerns. So thank you so very much, Dean Abate sir, for being with us. And indeed, your the session was incredibly insightful and thought-provoking session on a very critical issue of climate migration, and with a sharp focus on the complex dynamics of the problem between India and US, or with the India and US. Your analysis is truly underscored the dual challenges that both the countries are facing, and we are very grateful to you that you accepted our invitation and agreed to deliver a session on such a complex issue on the environment protection, and as well as the human right concerns of the climate migrants. On behalf of the Dean of Faculty of Law, GLS University, Dr. Mayuri Pandya ma'am, Vice Director Dr. Sneha Shukla ma'am, and we are very grateful, and I'm passing a thank you to you for accepting our invitation. We are very thankful to all our participants who have joined today in the morning for the session, and took a very active participation by asking the question and listening the sessions peacefully. Thank you all. Thank you so very much.
Thank you very much. And I put 2 comments in the chat. I'm happy to stay in touch on these issues, and I'm easy to find on LinkedIn. So don't hesitate to reach out and continue the conversation.
Surely we'll have a series of the sessions according, I mean, as per the convenience of institute and yours, sir. And we'll surely have, we'll look forward to have a future endeavors with you. And
Yes.
wishing you all the very best for all your future endeavors.
Thank you, and you as well. Thank you again for the invitation.
Thank you.
Thank you very much. Enjoy the rest of your day.